First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated if you're standing, and if you're not standing, that's okay. Welcome to the First District Court of Appeal electronic edition, and I apologize that we're a couple minutes late getting started. We were working with some technical issues. We don't anticipate any further technical issues, but if it should happen while you're arguing, we just ask that you stop arguing, and you're not going to lose any time. We'll get reconnected and then go forward with the argument. So don't freak out. It's going to be okay, but we don't think anything's going to happen. So we have one case on the docket this afternoon, Mandy Lynn Wyatt versus Polk County Board of County Commissioners. Counsel for the appellant, you may proceed.
May it please the court. My name is Nicolette Sambus. I represent Ms. Wyatt, and I'd like to reserve 5 minutes for rebuttal, if I may.
Yes.
This is a very serious case that concerns one of our first responders, and it requires this court's attention. It deals with the failure to apply the entire first responder statute, section 112.1815, to the claimant. Here, the JCC erred as a matter of law regarding denial of both medical and indemnity benefits for the injured worker, which is a first responder. There's no dispute regarding that. In fact, there's really no factual disputes in this matter. It's purely a question of law, where the standard of review requires de novo review for this court.
Counsel, I'll interrupt you there and get to a matter of importance, at least for me, and that is, do you read 112.1815 to provide two separate and distinct causes of action for first responders, that being a repetitive trauma exposure cause of action under 2A, and then a separate and distinct occupational disease argument under sub 5?
I don't believe that they are two entirely different categories of benefits. There's subsection 2, which is the umbrella. It allows for mental injuries without a physical trauma for our first responders, and that was in the statute beginning in 2007. Then, effective October 1st, 2018, the legislature deemed it a matter of great public importance to allow for a specific category of benefits, which is underneath that umbrella. So underneath the big category of mental/nervous injuries, there is a subcategory of post-traumatic stress disorder for our first responders that meet one of the qualifying events, the A through subsection K.
So basically, is it your position that the entire statute poses this psychiatric or mental injury as all being occupational diseases, that it's all in one category of occupational diseases? There's no room for an argument under a non-occupational disease diagnosis through a repetitive trauma argument?
I believe that it depends on your medical evidence. I'm not a psychiatrist, but there are mental nervous injuries that I believe could be based on a repetitive nature, I guess, or it could be based on the occupational disease. In 440 or in subsection 112.1815 subsection 5, it defines PTSD as occupational disease. And earlier on in the statute, subsection 4, it talks about occupational diseases for our first responders. So I believe that there is the category of benefits for mental injuries without physical traumas that can be occupational in nature. Perhaps it's a specific trauma that only one occurs and there's a specific date, or it can be the occupational disease, which is PTSD. Subsection 5 is very specific. It goes through, there has to be qualifying events, and if those elements are met, then the first responder is entitled to medical and indemnity benefits. If you only qualify for benefits under subsection 2, then you are only limited to the medical benefits. And I don't dispute that. The issue here is not, well, there's several errors that the JCC made in this case. First,
and I guess that's, one of what is important to me with respect to your answer to that question, and I look forward to opposing counsel's comments as well, is if I read the petition for benefits that's at issue here, it reads as asserting at least to me, alternative claims. It could be an occupational disease cause of action. It could be repetitive trauma or exposure. To me, it can be read as asserting all of those positions. In the motion for rehearing, the tone, at least that I took from your motion for rehearing, was we asserted alternative theories, occupational disease and or repetitive trauma, and JCC, you failed to even address that fallback repetitive trauma position. Am I understanding your argument correctly?
Yes, Your Honor. It is, the claimant is not limited when they file their petition for benefits in asking for only one. It's not one or the other and then that's it. There are multiple times when petitions are filed that seek temporary total / temporary partial. Obviously, you're not entitled to temporary total and temporary partial at the same time. And in this case, the claimant sought benefits, sought medical benefits for her PTSD, and sought indemnity benefits for her PTSD. At the final hearing, the transcript is clear. The argument is made regarding the occupational disease nature of PTSD. The statute is clear that that post-traumatic stress disorder, as defined by the DSM-5, which is uncontroverted, that the claimant, Ms. Wyatt, meets the category, is an occupational disease. And then the question becomes, what date of accident do you use for an occupational disease? The JCC neglects to address this and in fact faults the claimant for choosing the proper date of accident in this case. An occupational disease per 440-151 requires that the date of accident be the date of disability. That's clear in all in the Sedeco case that I cited to you in the brief. It's clear in the Jones case. Date of accident is date of disability. Disability is clearly defined in the statute as the date the claimant can no longer do the job she was doing. In this case, Ms. Wyatt could no longer work as an EMT as of November 27, 2018.
Counsel, and I'll certainly yield the floor to my colleagues who I'm sure have questions, but how do you merge that argument into the sentence that's contained under subsection 5D, which requires, it addresses notice of injury, but interestingly, the verbiage says a claim for this type injury has to be made within 52 weeks of the qualifying event. How do you merge that? How do you distinguish that, or how is that merged into your argument with respect to date of accident?
Well, Your Honor, in this case, first of all, I think it must be noted that notice defense was waived by the employer carrier. Right. And I think that that's extremely important to note because it was not raised in the pretrial. It was not raised in a responsive pleading. The claimant filed a motion to strike and the judge granted that. It was not cross-appealed either by the employer carrier for this court. Now, I understand. So with that being said, notice is off the table. That is a defense that was waived. The claim that's essentially been stipulated to by the employer carrier. Do you think there's significance in the legislature's use of the term claim in that sentence as opposed to its usual verbiage referencing only a notice of injuries to be made as opposed to use of the term claim? Your Honor, I believe this statute needs to be applied as written, right? And I agree that it is that this is a clear, unambiguous statute, and the legislative intent needs to be followed. So when you look at the statute directly, I'll read from the statute. It says, the time for notice of injury or death in cases of compensable post-traumatic stress disorder under this subsection is the same as section 151 subsection 6. That is the same, meaning date of accident equals date of disability. But then it does say, and is measured from one of the qualifying events listed in 2A. Now, Ms. Wyatt, she unfortunately suffered from not just one qualifying event, but 6 separate qualifying events, with the most recent qualifying event being in June 2018. I don't need to elaborate further on the tragic nature of the events that she witnessed and was a part of. But it's extremely important to understand that all of these combined contributes to the diagnosis of post-traumatic stress disorder, and that's outlined in DSM-5. Now, we're not doctors.
Well, counsel, but the diagnosis would have been based on symptoms, and the symptoms would have flowed from the qualifying events. So if we're dealing with trying to figure out whether the statute applies to the new statute applies to your client at all, the question, at least that I have, is what is if those qualifying events all occurred before October 1, 2018, and as you said, she suffered from those qualifying events. And on top of that, it appears that she had symptoms even going as far back as 2016. Do you agree that she didn't have a claim as of October 1, 2018, or on September 30th, 2018, she could not have filed a claim? Let's start with that. Would you agree with that?
That she could not have filed a claim under subsection 5?
Sure.
Question, Your Honor?
Yeah.
Yeah, I agree. The effective date of the statute is October 1st, 2018. The claimant didn't have a date of accident on September 30th, 2018. She was still working. She continued to work as an EMT paramedic up until November 27th, 2018. She was doing her job. The triggers, which is one of those elements of PTSD, and I think that that's important, is it's not, with this type of diagnosis, it's not an accident by trauma, which is what the judge of compensation claims essentially treated it as. This is a condition that, yes, I have qualifying events that have led me to develop post-traumatic stress disorder, or I'm sorry, not me, but Miss Wyatt, but it's the triggers, the nightmares, the inability to sleep, the inability to function, and the cumulative effect of these triggers led to her date of disability, which is her date of accident. And that's the effective date, and that is post-effective date of the statute, which is subsection 5. And I must note that subsection 5 was only an addition to our First Responder Act. It did not take away any of the existing laws that were before, including subsection 2, which Your Honor, Ms. Thomas, or Your Honor, Judge Thomas referenced, that subsection 2 has always been in the law since 2007. In this case, the judge of compensation claims denied medical and indemnity benefits for a mental injury for Miss Wyatt. She was denied all benefits.
But don't you think that the implication of your reading of the application of the statute, that would bring in countless latent claims out there? There are a number, I imagine there can be countless employees out there that had qualifying events that occurred prior to October 1. And suddenly there can be all kinds of liability for carriers and employers that maybe the legislature did not intend to create.
Your Honor, I believe that the legislative branch was clear. They deemed this matter of great public importance to address our first responders, our community service members who have these sorts of injuries and that are specific in nature. Yes, you may have a qualifying event that has occurred before October 1st, 2018, but if you have been able to continue to serve our community and the effects of this post-traumatic stress disorder did not become disabling as defined by occupational disease until a later date, then that's the date of the statute that should apply to your accident. In this case, Miss Wyatt, continued to work, she continued to serve. This legislative was clear in defining this disease, defining PTSD as an occupational disease. And it is clear in the statute, the law must be applied as written, that occupational diseases are not, the date of accident is the date of disability. I mean, she continued to work up until November 27, 2018.
Well, counsel, what would you say to carriers though that had not rated for this risk? So, the legislature as of October 1, 2018, the statute goes into effect, and by your argument, there's a whole bunch of risk that automatically become occurrences suddenly that insurance carriers may not have rated for. Doesn't that impose some sort of taking or some sort of implicate a property interest in the hands of the carriers?
Your Honor, again, I'd like to point out that it was that by the legislative noting that it was deemed a matter of state importance, that it overcomes any type of taking or unconstitutional argument. Here in this case, and I think that it's known by all of us that that rates have been going down for carriers for quite some time now. And in this case, we're expanding benefits in workers' comp to our first responders. And it doesn't necessarily open up a whole can of worms where we're going to be providing benefits for our first responders that don't need it. This is something that's extremely important, where the suicide rate of our first responders is more than the deaths that are in the line of duty. This is an enactment to help prevent deaths that could be prevented by simply providing medical care. It's not something where you're taking away from our counties or our carriers. It is providing something that is clearly required and has been deemed extremely important by the legislature. I think it's important to go back and quote Marbury versus Madison, where the duty is to say what the law is. It's the job of the courts. The interpretation of the laws is the proper and peculiar province of the courts. That's an Alexander Hamilton quote. And although I'm going way back, it's a fundamental principle that was not applied here by the judge of compensation claims. The final order should not stand. It violates the clear application of section 112.1815, subsection 5, and subsection 2. Both medical and indemnity benefits were denied for Ms. Wyatt. I know I'm into my rebuttal period, so I'd like to reserve the rest if I may, unless there's any more questions.
Thank you. Counsel for the appellee, you go ahead.
Thank you. May it please the court. Tom Vecchio of Lakeland on behalf of Polk County Fire and Rescue. I would like to start with the questions you raised, Judge Tannenbaum, and that relates to the ability of employers and carriers to prepare for these claims from an actuarial and underwriting standpoint. With the claimant's reasoning, an employer and a carrier could not adequately prepare for this type of claim. To adopt the claimant's reasoning, an injured employee, a first responder, could have had a qualifying event that occurred 25 years ago and file a claim today, asserting that today is his or her date of accident, and the employer carrier would then be responsible for providing both medical and indemnity benefits for an event it could have never envisioned. Certainly not before the 2007 statute and not before the current statute. So while I agree with the claimant that this statute was designed to address an issue that the legislature deemed important, the law cannot be implemented in a way to cure all ills.
How would you interpret the section 5D, specifically the sentence where it says a claim must be properly noticed within 52 weeks of the qualifying event? Is it your position that goes strictly to notice of injury, or the use of the term claim sort of puts a cap on these claims that the psychiatric condition must manifest itself within 1 year of the qualifying event?
My position, or rather my client's position, would be that there is a clear distinction between two different things, notice and claim. Providing notice of an industrial accident is, in the most plain circumstance, an injured worker notifying his or her employer that he or she was indeed injured on the job. An injured worker then has 2 years within which to file a claim. So in recognition of this unusual carve-out as a government employee presumption statute, where the burdens of proof are intentionally turned 180 degrees out of phase, the legislature, I would submit, recognized this problem with claims arising today from events that occurred years or even decades ago, and therefore inserted this language in the statute to create temporal limitations between the event and the time within which the claim is reported, and then the time within which the claim is prosecuted through a claim. Now, the claimant's argument in this case would utterly divorce the triggering event from an employer carrier's obligation to pay benefits. And the court has never gone that far. The court has never said that there is allowed to be anything but a strict temporal relationship between the event that gives rise to the employer carrier's liability and the employer carrier's duty to pay. That concern is even more so important in workers' compensation litigation, as evidenced by the fact that we have a 2-year statute of limitations, whereas a general negligence action has a 4-year statute of limitations. So these time constraints are very important for administration of the workers' compensation system. And
Mr. Vecchio, could you address the issue of appellant argues that we define PTSD under these circumstances and applicable to these facts as a, quote, occupational disease. We have, 50 plus years of case law indicating date of accident for occupational disease is date of disability tied to wage analysis. So they pled under an occupational disease theory, the date of accident equating to date of disability. And then now they come into a merits hearing and the judge says no, quote, accidental or traumatic event happened on that day, therefore you've proven no accident. How is that not a due process violation for claimants?
because again, this is a government employee presumption statute, which reverses the burden of proof for each party. And because it is the employer carrier that carries the burden of proof with government employee presumption claims, then the legislature is at liberty to impose additional restrictions on claims for benefits related to benefits under Chapter 112. And that is why the legislature put the timeframes in subsection D that indicate the claim must be reported no later than 90 days in accord with section 440.151, but that the claim must be brought, the petition must be filed, the litigation must ensue within 52 weeks of the qualifying event or the diagnosis of post-traumatic stress disorder, whichever occurs later. So the legislature saw that problem and they addressed that problem by constricting the time frame within which these claims must be brought, which is perfectly within the legislature's purview. That is something the legislature is absolutely entitled to do.
So you would propose that this court carve out, for purposes of this statute, that the date of accident, although an occupational disease labeled by statute, the date of accident is not date of disability, but is a special category, meaning must be brought or manifested within 52 weeks of a qualifying event.
Yes, and that relates to a rule of statutory construction that I wanted to discuss today. Statute 112.1815 is more specific than 440.151. And for that reason, the more specific statute controls over the more general statute. That is why there are special rules related to this government employee presumption claim, as opposed to the more traditional exposure occupational disease type cases, exposure to noxious chemicals or repetitive motion. Those we clearly understand as occupational diseases, but given the difficult nature of assessing and evaluating psychiatric conditions, which the court has traditionally viewed somewhat askance, the court has previously referred to psychiatric claims as suspect. I don't think that's the legislature, I don't think that's the nomenclature the court would use today, because that word kind of carries a negative connotation. But the history of psychiatric claims as construed by this court has always been to look at psychiatric claims a little bit more closely. And when that applies to government employee presumption claims, the standard of scrutiny is heightened even more. In the answer brief, I cited a case with an injured worker named Clark, and I quoted rather extensively from the opinion as written by Judge Irvin. Judge Irvin sat on this court for decades, and he probably wrote 100 workers' compensation opinions. And you can tell from that quoted language the heightened scrutiny that the court must apply to government employee presumption claims. Mr. Clark in that case was found to have cardiovascular disease and was instructed by his treating physician to refrain from working. Mr. Clark was a firefighter, and he met every element of the firefighter statute, but the fact that he was not employed by a fire control district. And in reading the labors set forth by Judge Irvin, you can tell that he is struggling with application of the statute as written, but that's what he does. He said, I cannot understand why the legislature has thus far not agreed to bestow these benefits on firefighters like Mr. Clark, who meet every other element of the definition of firefighter, but for the fact that he was not employed by a fire control district. But Judge Irvin concluded that's what the statute says, and that is how I must apply this statute.
Well, counsel, why do we even, before we get to question of statutory construction, we're dealing with a question of whether the statute applies, I would call it retroactively, to a situation like this. Do we need to get to statutory construction, and do we need to get to when the disability occurs versus the accident or injury, to when we're applying a new statute that goes into effect on a particular date? Isn't it a question of whether it gives rise to a new substantive right and the impact that it might have on, say, your client or the carrier, also your client? But why do we get to the statutory construction question before we address the question of whether this creates a new substantive right retroactively?
I agree. The question of prospective or retrospective application is the primary question. And as the court may have noted in the employer carrier's answer brief, that was the first point raised by the employer carrier. This statute must be construed as a substantive statute because it affects an employer carrier's obligation to pay benefits. And the law is very clear that the statutes of Florida are deemed to apply prospectively only unless there is language in the statute indicating that it is intended to apply retroactively. And even at that point, the statute cannot engender constitutional infirmities, and I would submit that is exactly what would happen with retroactive application of this statute.
Does it matter that we're dealing with a political subdivision here as an employer?
No, because I would assert the political subdivision has the same constitutional and due process rights as a private employer. And a political subdivision of the state, whether that be something as large as the state of Florida or something as small as Polk County, still has the ability must have the ability and the right to adequately prepare for risk that it must face. The claimant's argument here is similar to asserting that if I buy a new car today, my auto carrier that insured my beat up pickup truck 2 years ago is now on the hook for liability if I crash that new car. The premium was charged and the rates were considered based on the risk the employer and the carrier faced at that time. And to submit, or rather to argue, that employers and carriers now face substantially greater financial exposure because of a new category of benefits created by the statute would subvert the underlying rights to fairly charge premium to carriers and to base risk assessment on known and quantifiable risk.
Well, counsel, let's assume I disagree with your assertion that political subdivisions would have due process rights. Should we still consider, or should I consider, the carrier's due process rights in some way? And before you answer that, does it make a difference whether it's a retro-rated policy versus some other type of policy?
That I don't know. I can't say I know enough about policies and calculation of premium to answer that question, Your Honor. I'm at a loss on that one. But a fundamental...
If you could address this, I don't think it's going to be a big debate as to whether this is a substantive change or not. I think here, under these facts, it becomes, what's the trigger date? Is it the compelled date of accident, which the claimant listed under their argument as occupational disease being the date of disability, or is it the qualifying event which determines which version of the statute applies?
I would submit there's a third possibility as well, the diagnosis of PTSD, because that is what the statute addressed. And you raise a point, Judge Thomas, that Judge Arthur raised in the final compensation order. Judge Arthur said it is the claimant who posits the date of accident. It is the claimant who determines the date of accident under which he or she is going to prosecute claims for benefits. And in this case, by virtue of the claimant having selected November 27, 2018 as the date of accident, she is obliged with procuring or prosecuting claims for benefits under the statute that applies on that date. Now, that brings to the forefront an argument regarding a point I raised in the brief, and that is the claimant's pleading. The claimant could have pled this claim in the alternative. The claimant could have advanced a claim for medical and indemnity benefits under the new statute or a claim for medical benefits under the old statute. The evidence is clear that Ms. Wyatt never had a physical injury while working for Polk County. She admitted that at deposition and at final hearing. The claimant could have prosecuted claims under different dates of accident or merely set forth alternative theories of recovery, but she did not. One of the points that Ms. Sambus raised in her portion of the case relates to the notice requirement, but the notice issue was multifaceted. The claimant argued that the employer carrier did not assert a notice defense with respect to subsection D, the reporting within 90 days or filing the claim within 1 year. But the notice issue also went to the claimant's assertion raised for the first time in her trial memo that the claimant was entitled to medical benefits only under the old law. Now, the only claim.
And if we look at this from a procedural standpoint, when I look back at the petition for benefits that's at issue, what was pled was number 1, accident, number 2, repetitive cumulative trauma and or series of events, 3, and 4, exposure. I mean, that pretty much covers the gamut as far as I'm concerned with respect to occupational disease, repetitive trauma, etc. How did not place the employer carrier on notice of those alternative causes of action?
Because for 2 very important reasons. First of all, the claimant listed the diagnosis of PTSD. Secondly, the claimant listed a single date of accident, November 27, 2018. Now, the diagnosis of PTSD was set forth in the statute for the first time on October 1, 2018. Prior to that, the statute referred only to mental and nervous injuries. But there's 2 very important points that are perhaps most important in this analysis, and that is claims for indemnity benefits that were not available to injured workers before October 1, 2018, and then statements by counsel prior to the opening of evidence when we were discussing the claims and the defenses, and counsel said a couple of times, the real issue here is the indemnity benefit claim. That's a new law claim, not an old law claim. And that is the conclusion that Judge Arthur reached after considering the single petition for benefits and the arguments of counsel and the evidence. So this was clearly posited as a new law claim. It was advanced as a new law claim when the claimant had every opportunity to set forth an alternative claim for medical benefits only. It was not until the claimant's trial memorandum when the claimant averred for the first time that the employer carrier must pay medical benefits only, even if the court finds she did not carry her burden of proof under the October 1, 2018 statute. Okay. So that is part of the employer carrier's notice defense.
Well, counsel, based on the claim, let's assume it was a claim under the, or it could be read as just a claim under the new law. Are you saying that the claimant was not asking for medical in addition to indemnity under the new law claim?
No, she was asking for both medical benefits and indemnity benefits.
So if she was claiming both anyway, where is the prejudice if it were an alternative pleading? So if she's pleading medical, regardless, one way or the other, under the old statute or the new statute, why was it error, or why was it not error for the JCC to not award at least the medical part of it under the old statute, if not the new?
Because it is the responsibility of the claimant to set forth the claims within the parameters of the statute that allow an award of benefits. And the JCC found in this case, as the employer carrier argued, and that was that this was a new law claim. And the claimant was asking for indemnity benefits. And again, this is what her counsel at trial asserted as the most important element of the claim.
But not the only element.
That is true. That is not the only element of the claim.
Right.
But an award of medical benefits only would have caused the JCC to infer elements in the pleading that were not there. The JCC would have to look behind the petition for benefits and say, well, the claimant seemingly pled in the alternative. This could be construed as a claim in the alternative when in fact it was not. And for that reason, the claimant went forth as exclusively a new law claim, as opposed to an alternative claim under the old law.
Are you saying that the JCC was confused that PTSD might not be a mental health claim without physical injury, such that medical couldn't have been awarded?
No, I don't think the court was confused. I think the court reached the same conclusion the employer carrier did, and that was that this is exclusively a new law claim without the claimant asking for benefits under any portion of the statute before subsection 5. It was clearly a subsection 5 claim, and that is how the court construed it. Now, there's another element of this statute that I wanted to point out to the court's attention, and this is what I call a drop-dead element of the statute, because it's very plain and it's very clear, and that is subsection 5A2, which says in order to perfect a claim like this, the first responder must be diagnosed with PTSD by a licensed psychiatrist who is an authorized treating physician. There was no authorized treating psychiatrist in this case. The only two medical opinions that were submitted were the opinions of Dr. Ruano and Dr. Kaplan, both of which were independent medical examiners.
Well, if you denied compensability, how are you going to acquire an authorized physician to diagnose the condition?
That is clearly an argument that can be raised with respect to that statute, Your Honor. But in considering that statute, our first obligation, or our first duty, I should say, is to look at the plain language of the statute. And in looking at that statute, the language is abundantly plain. And we must then assume that the legislature understood the import and impact of every word, every phrase, every clause it writes into every statute.
Well, if we accepted that interpretation and application, there would never be a compensable claim under that statutory section, ever. An employer carrier could deny every claim, therefore there would never be an authorized treating physician, and it would render the entire statute meaningless.
Only if political subdivisions of the state who employed first responders acted with a remarkable degree of bad faith. That is the only way this statute would serve as a bar to anybody bringing such a claim. This statute is clear and unambiguous, this portion of the statute, and it must be applied in accord with its plain language. I see that I am out of time, so I would merely conclude by asserting that the order that is the subject of this appeal is well-reasoned, it is clear, and that it should not be disturbed on appeal. Thank you.
Thank you, counsel.
Your Honor, I'll address the most recent point made by Mr. Vecchio with regards to subsection 5A, subsection 2. The Cepides case from 2013 makes it clear that authorized treating provider, that term authorized, it's not defined in the statute. Authorized or authorized can mean possession. You go to the Black's Law definition when the common or ordinary meaning is not clear, and it's possessed of a legal and rightful power. This court made it clear that authorized treating providers does not mean just somebody that the employer carrier authorizes. It means IME, EMA, or authorized treating provider. It means an admissible opinion under the statute 440.13.5c. So I think that argument is irrelevant, but I do appreciate Mr. Vecchio pointing out that the language of this statute is clear and unambiguous, and that's what needs to be followed. It seems to be that the employer carrier's position, and essentially what the JCC did in this case, was add obstacles that the legislature did not intend with this case. I know that this court may be referring to old law versus new law just simply for semantics, but I think that it's clear that this is not an old law versus new law case. I am not arguing a retroactive application of the statute. I agree that these are substantive rights that need to be applied for dates of accident that are after October 1st, 2018. Subsection 2 is still in the law. It is meant as a catch-all. When the legislature added the post-traumatic stress disorder, it was a subcategory under the mental nervous injuries. So we have a claimant who meets the categories of subsection 2, and now because her date of disability, her date of her occupational disease is the date of November 27, 2018, the statute that's in effect includes subsection 5. Subsection 5, it goes through specific elements. And if you apply the law as it is written, the claimant is a first responder. That's under number 1, subsection 1. Acting within the course and scope of her employment, that is not in dispute. Both Dr. Khan and Dr. Ruano are IMEs, psychiatrists, licensed under the statute, allowable, admissible opinions, opined that she has PTSD related to her employment. And I think that that goes on to the notice issue that Your Honor was talking about, and also that Mr. Vecchio brought up, is that notice has to be provided by a psychiatrist, an admissible psychiatric opinion. Before the claimant saw Dr. Rowano or Dr. Kaplan, she was only treating with a counselor, and that was Mr. Minter. And he was the one that took her off of work for her FMLA. He is not a psychiatrist with an admissible opinion that was able to provide the opinion that is required under the statute. So the claimant did, sorry.
Can I ask you, before we run out of time, I wanted you to address is there any significance that we should give to the 2016 claim that you mentioned at page 10 of your brief and is found at 316 in the record?
The significance of that is the notice, Your Honor. And as Judge Thomas noted, the 52 weeks after a qualifying event, well, Ms. Wyatt had several qualifying events. Her first one was in 2016. She goes off on FMLA effective November 27, 2018, or the day after. And she reports a workers' compensation claim. She is a first responder that doesn't know the law, doesn't know what's going on, but she knows she needs help and she's asking for help. And so when they fill out workers' comp documents, the first qualifying event that pops up is 2016. And that gets denied within by December 2018. The employer carrier had notice. It is well within the 52 weeks of a qualifying event. It is because her last qualifying event was in June 2018.
But she wouldn't have been entitled to indemnity benefits back in 16. Did you agree with that?
I do agree, Your Honor.
Okay, so something happened, say October 1 of 2018, that would suddenly entitle her to indemnity that she didn't have before. Do you agree?
Was there an event after October?
Well, the thing that happened on October 1 is that the statute went into effect, the new law.
I agree.
So October 1, 2018, the statute gave her a right that she didn't have before to recover on these, on whatever she was suffering from prior qualifying events.
But I don't believe she had a date of accident because she was still working. So, Your Honor, if she were to file for benefits, say September 30th, or any time before that, if she was continuing to work, the indemnity portion of the statute is essentially irrelevant. She doesn't have a date of accident under occupational disease because she's still working. And those are several cases that even the employer carrier cited to in their brief that you don't get a date of accident under occupational disease if you're still working. I see that my time has expired, and so I'd just like to note that the clear and plain application of the statute applied in this case, as it was not in the judge's final order.
Thank you, counsel. Thank you to both of you for good advocacy on an interesting question. This being the only case before the court, we now stand adjourned. Thank you.
Thank you.
Thank you.